In April of 2019, markets regulator Sebi had directed India's largest board's National Stock Exchange to disgorge 625 crore rupees for alleged violations of the Stock Exchanges and Clearing Corporation regulations over lapses at its co-location facility. The NSE was also told to pay an annual interest of 12% to be calculated from April 2014 on the total fine. Under the disgorgement process, any party that is found guilty of profiting from an illegal act has to shell out the profit amount obtained from the said act. Now, about 3 years later, the Securities Appellate Tribunal has set aside the Sebi order, saying the NSE has not indulged in any unethical act or unjustly enriched itself. The NSE's former top executives, Chitra Ramkrishna and Ravi Narayan, also got some relief. But the SAT directed the NSE to deposit 100 crore rupees for lack of due diligence in following its own norms and circulars. This amount will be adjusted against what has already been paid by the NSE, while Sebi will have to refund any excess amount to the exchange within 6 weeks. The SAT also observed that there had been no finding that Ramkrishna or Narayan made any wrongful gains. It set aside the market regulator's direction that they disgorge 25% of their salaries drawn during a certain period. The direction prohibiting them from associating with any listed company, market infrastructure institution, or any other intermediary for 5 years was also set aside, substituted for the period already undergone by them. The co-location facility was launched by the NSE in 2009. It allowed traders and brokers to establish their IT servers within the premises of the data centers of the boards in return for a fee. These participants were able to access information about stock prices faster, resulting in faster trade execution. However, a whistleblower wrote to Sebi in 2015 alleging market manipulation by certain brokers using this facility. The co-location technology's implementation was carried out under the supervision of Narayan and Ramkrishna. The Central Bureau of Investigation, which has also been investigating the matter, arrested Ramkrishna in March last year. However, she was later granted bail. Coming back to the recent SAT order, the tribunal came down heavily on the market regulator. It noted that when serious allegations were made against a first-level regulator, namely the NSE, Sebi should have been proactive and conducted its investigation seriously. Instead, the SAT found that Sebi adopted a slow approach and placed a protective cover over the NSE's alleged misdeeds. The SAT also said that there was laxity at the NSE, which resulted in unequal distribution of IPs on the servers. Meanwhile, it allowed Sebi's direction to initiate inquiry against NSE employees. It also directed the markets regulator to consider the charge of connivance and collusion of OPG Securities and its directors with any employee or official of the exchange. The violations committed by OPG have been affirmed. As a result, Sebi has given 4 months to recalculate their disgorgement. The SAT said that OPG had remained connected to the secondary server in spite of warnings. OPG gained an advantage in accessing the data faster than other brokers due to a low load on the secondary server. The tribunal also pointed out multiple lapses in the various orders passed by Sebi in the co-location case, noting that there were contradictions in the findings arrived at by Sebi's whole-time member. Pointing out one of the anomalies, the tribunal said that in order against the NSE, the whole-time member held that an early login by the trading member and OPG created an advantage. According to the whole-time member, a trading member who logged in first would be disseminated the data first at the start of the trading day, and would therefore have an advantage over other trading members. Meanwhile, in the OPG matter, the whole-time member held that the early login by OPG did not lead to any unfair advantage. However, the SAT has affirmed the Sebi whole-time member's decision to prohibit the NSE from accessing the securities market for 6 months and directed it to carry out system audits at frequent intervals. So, has the SAT order changed the course of the co-location case?
So the current SAT order definitely changed the course, the way entire co-location matter was being looked at. However, it is important to understand that the way co-location works, retail investors are not impacted in any way in this particular matter. Now, since the time this co-location related issues were highlighted, Sebi has already taken various policy measures, and in fact, the entire tick-by-tick facility which was there at NSE has been changed from April 2014, and now it has moved to something called as a multicast TBT. So therefore, such kind of recurrence of irregularity is minuscule. Also, one thing which needs to be remembered is that the order which has been set aside is not of the penalty order, which is a separate order and is pending at SAT, which is with respect to 25 lakh rupees penalty on the then MDs and CEOs, as well as the 1 crore penalty on the exchange. So this order is technical and not substantive in that sense. This is on the technicality on when disgorgement can be called, can be imposed, and whether this is a fit case for imposing disgorgement, especially when there is no finding of a personal profit being derived or computation of that amount in the Sebi order.
Also, what are the implications for the NSE and Sebi?
It remains to be seen whether NSE under the new management is going to appeal this order in Supreme Court, more so because NSE is looking to come out with its IPO in due course. However, Sebi's situation would be tricky because the SAT order clearly nudges Sebi to introspect and put its house in order. It has remarked that Sebi was slow, casual in its approach, and was taking twists and turns depending upon what transpired at the parliament floor. These remarks are very damaging to Sebi, and hence Sebi will have to take a call whether to appeal this order in a full manner or in a limited way to seek only these remarks removed. As you know that in the Supreme Court of India, appeal against a SAT order is only and only on the questions of law, and SAT is the first appellate authority to decide facts and law both. So therefore, facts by and large have been determined in the SAT order. We'll have to wait and see how this entire controversy takes a new turn, especially under the new management, and given the way exchange is looking to come out with an IPO. However, for introspection for Sebi, this is a sort of repeat of a history. And let me remind it that somewhere around 2007 and 8, Sebi had passed similar kind of a disgorgement order against depositories in a multi-demat scam called Rupal-Ben Panchal IPO scam. Even 2 decades back, Securities Appellate Tribunal's position was similar, that till the time profit has been calculated and arrived at, no disgorgement can be directed.
The order passed by Securities Appellate Tribunal is one another order of setting aside order of Sebi in certain aspects. It is yet another reminder to the regulator that Sebi needs to act very cautiously within the laid down legal principles, particularly in cases where it comes to conclusions of fraudulent activity and consequent disgorgement.
The tribunal has criticized both the country's largest stock exchange and markets regulator, highlighting lapses in their conduct of duties. This situation does not bode well for confidence in India's markets and should be rectified immediately.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.